Hi there. This is Amanda Kay, program attorney. I'd also like to introduce the presenters from Delaware. We have with us Commissioners Andrew Southnade and Luann Berry, and we hope to bring in the Family Court Enhancement Project Coordinator, Ellen Cooper. We're having some technical difficulties there, but we're going to be working behind the scenes so we can bring her on shortly. Just to provide a quick overview of the Family Court Enhancement Project, the learning objectives for today are to describe the purpose of the FCEP project, describe the importance of court and community readiness for undertaking this work, and identify steps that can be undertaken for system assessment and improvement in your own jurisdictions. Now, the Family Court Enhancement Project started because we know that custody is a huge problem in domestic violence cases. Studies have come to different conclusions, but it's estimated that between 25 and 75% of disputed custody cases have domestic violence present. We also know that abusers are twice as likely to seek sole custody, and they are successful in obtaining sole or joint custody in 50 to 70% of the cases when custody is disputed. So the goal of the Family Court Enhancement Project to address these concerns is to improve the family court response to divorce and parenting cases involving domestic violence so that parenting arrangements protect the emotional and physical well-being of victimized parents and their children. There are several national project partners for the Family Court Enhancement Project. The National Council of Juvenile and Family Court Judges coordinates the project. Other partners are the Office on Violence Against Women from the U.S. Department of Justice, the Battered Women's Justice Project, the National Institute of Justice, the Center for Court Innovation. 4 sites were selected to participate in the project. It's a demonstration initiative, so each site was provided some funds and a lot of assistance. 4 sites were selected: Multnomah County in Portland, Oregon, the Family Court there, the Family Justice Center in Minneapolis, Minnesota, Hennepin County, the Circuit Court of Cook County in Chicago, Illinois, and the Family Court for the State of Delaware, today's presentation. The Family Court Enhancement Project started by gathering as much information as possible from these 4 sites, documents, holding stakeholder events, launch events, mapping the courts, talking to different having conversations with different affinity groups like advocates, survivors, attorneys, just seeing all the information that we could get, and then identifying challenges and contributing factors and setting some priorities. The next phase was the planning phase. This was about a 4-month period where all that data that was gathered, additional data continued to come in. Some systems assessment went on, and each site formed their own specific work plan and identified key activities that they thought would help improve outcomes for victims and children in their jurisdiction. And then where we are now is the implementation phase. Each site is being provided intensive technical assistance. There's a lot of hard work going on at all 4 sites. They are doing some amazing work. They're continuing the conversation with all the stakeholders in their communities, and we're starting to see some systems change, gathering data and seeing what's been successful, what might need some tweaks, and whether there's any unintended consequences. Once the period winds down, we're going to be gathering all the information about how the program went, see what lessons were learned, and put that information out there for others who might want to try this work. And I will turn it over to Delaware now.
And this is Commissioner Berry. I'm one of the presenters here today from Delaware. I think, as you probably could understand from Amanda's introduction, we are, as I understand it, the only statewide site identified for this demonstration project. That's probably not surprising because we're probably smaller than many counties and certainly some of the other counties that are participating with us. With that said, we've laid out an agenda here today let me see if I can advance the slide. Get to that. Essentially, we're going to begin by giving you an overview of a little bit of synopsis about the state itself, also, and then specifically our family court system here in Delaware and some of the strengths and challenges it presents. Obviously, our main goal is to begin exactly as Amanda said, to try to get around and find ways of improving outcomes for children, particularly in custody situations, and obviously particularly where there's been domestic violence involved in their lives. We began our piece of this by both developing a management team, and we'll give you a little more information about the composition of that in a minute, as well as a larger collaborative work group from more stakeholders outside of the basic court structure. Not surprisingly, we began with a planning phase, and then we have developed, as time went on, implementation goals after we identified the issues that were unique maybe to us that we were struggling with or at least wanted to try to improve. We've developed a variety of activities that we are probably half better through implementing. The way we went about tackling most of the actual on-the-ground work identified through the planning and implementation projects, I guess, was divvying out the work into a differentiation subcommittee, and I actually co-chair that with one of our community legal aid attorneys who represents victims of domestic violence. We have another subcommittee that Commissioner Southmaid, who will be talking to you in just a minute, chairs, which is called the Access to Justice Subcommittee. And that committee is what I'm going to loosely call more procedurally driven on front-end processes. The differentiation subcommittee is trying to get at where exactly what information is available to judges and commissioners in our state when they're making custody decisions. Some of our work as well has been complemented by a workload analysis that the judges, commissioners, and mediators in our state are actually undergoing for the next couple of months, 2 to 3 months, in terms of developing how much time we actually spend on different types of activities that we do. And that's another project developed under another, the state court administrators, I believe. We'll also take you through where we see ourselves at currently as a management team within the court, and then also where we see ourselves obviously going for the next year or so. So that's our agenda today. We've got a slide here that just gives you our names in case any one of you would ever want to catch up with us. We've already talked about Commissioner Southmaid, Commissioner Berry, that's me, and Ellen Cooper, who is our project coordinator. I'll also say as an aside, while Ellen has joined us to be the project coordinator, Ellen also served as a commissioner previously on our court, so she brings with her a wealth of experience as well. She's got it from all sides. With that said, I'm going to now turn it over to Commissioner Southmaid to tell you a little bit about our small but very great state.
We've got just under 1 million residents, and as Commissioner Berry was saying, we're smaller than many counties. Indeed, I did look up that Hennepin County has 1.3 million residents, and by the information I could find, that their domestic violence caseload is right in line with ours. So that was interesting to see. We only have 3 counties, and that allows us to do a lot of experimentation by trying things in individual counties, but having not too many. 8.3% of our population is foreign-born, and that's one of the things that our counties can take advantage of. In that Sussex County has a higher degree of foreign-born than other counties, so we'll be able to experiment with that. Newcastle County is our large county. It has about 60% of the population, and while the Sussex County is larger than Kent County in population, actually population of children is almost exactly the same, because Sussex County is a target for retirees. It's where the beach is, and so a lot of people come. In the summer, we're even bigger. But as we go over to our family court system, we're a unified family court, meaning that the court spans the whole state. It's one organization. We have a chief judge. We have 16 other judges, 3 each in the lower counties, and whatever's left from subtraction in Newcastle County, in our largest city, Wilmington. We also have 16 commissioners. So we basically have a judge for every commissioner, with the exception of the chief judge. We do try to ascribe to the principle of one judge, one family. I say sort of with that because there are exceptions. You do not go to the same judge if you have a PFA, and that's our Domestic Violence Protective Order, what we call PFAs, or Protection from Abuse Orders. And misdemeanor domestic violence criminal matters go to a commissioner and not to a judge, and there's no association with one judge, one family in either of those areas.
Yes. I hate to interrupt, but I've just now worked out the technical difficulties we were having with the call-in system. This is Ellen Cooper, and I'm the project coordinator, and have now been able to join. I will take over progressing the slides if you and Commissioner Berry would want to continue, and then I will present information about the work groups and the collaborative group.
Okay.
That saves me because I was struggling with the slides, so thank you.
So the one judge, one family in Delaware is probably better described as in the divorce context, in that if you get a divorce and have ancillary matters, that is property division, alimony, etc., that will be paired up with your custody if that is filed at the same time. It's those traditional civil matters. But as of yet, domestic violence has not yet been pulled into that pattern. We have jurisdiction where domestic violence may be a factor in, as I was saying before, misdemeanor domestic violence. Felony domestic violence would go to our superior court where jury trials are available. Civil protective orders, as I said, what we call PFAs, and custody and visitation, guardianship, of course. We do have jurisdiction over a lot of other things. About 40% or more of the activity in our court involves child support. What else do we do?
Our court also does termination of parental rights in foster care, dependency, neglect cases, and that, in fact, is something that tends to take up a great deal of our judges' time. And in a couple of slides, we'll be making distinctions to help you understand the way we divvy up work here between judges and commissioners. So another big chunk of our jurisdiction, in fact, is dependency, neglect, foster care work.
So on our next slide, we've pointed out that judges exclusively hear final custody and visitation petitions, guardianship petitions, and appeals from all commissioners' decisions, while commissioners exclusively hear misdemeanor domestic violence and the Domestic Violence Protective Order or protection from abuse matters. We have also a diversion services unit staffed by mediators. All custody petitions used to go to a mediator, but in recent years, now by statute, are required to bypass mediation. Mediators also perform a function in our Domestic Violence Protective Order calendar, in that when people come in for those calendars, they are first greeted by a mediator who shuttles between them to see whether or not a consent order can be negotiated. And then they are taken before a commissioner either with their consent order or for a trial. Our project is reviewing the mediation process, both as it regards custody and how it regards domestic violence protective order, their involvement with that, and we'll be getting into that later.
It's hard, this is Commissioner Berry, it's kind of hard not to kind of see the irony, perhaps, of the importance of looking at that system, because in cases where mothers and fathers come in for protective orders, often after a very critical or acute event, then we do in fact allow some sort of, as Commissioner Southmaid said, shuttle mediation there, even though it's very, perhaps a very hot and intense time for them. On the other hand, once there's been some protective order entered or there's been other crimes committed around domestic violence, then mediation is bypassed. So it's kind of a little wacky situation.
Well, and in the context of this whole project, it's hard not to see and be skeptical of our whole system where judges are doing exclusively all the custody work. Well, I should just say one category of judicial officers are doing all the custody work, and another is doing all the domestic violence work. They each have their separate specialties. And this whole project is trying to figure out how to mix those specialties and how to make sure that domestic violence information gets proper consideration in deciding custody cases, and not just deciding, resolving custody cases, whether it's by negotiation or in a trial.
And that might lead us, I guess, and I'm not sure how we get a poll question up, but we were interested in, for those of you who have joined us from specific jurisdictions, we were questioning whether in your jurisdiction different types or levels of hearing officers do custody or parenting time determinations, depending on whether that comes in through a protective order process or a custody decision. So I'm not sure how we pop up that poll. Alicia, are you with us? Okay, there we go. All right.
We're going to come back to the other question.
Okay. Can we finish out the poll, or do I need to wait? Can I go on? All righty. So I see the poll is closed, and it looks like about, and of course the numbers are pretty small here, but it looks like some of the jurisdictions, in fact, do have what I'm going to charitably call a challenge in terms of having different types of hearing officers, but obviously some don't as well. All right. Thank you, guys. With that said, if we could move on, and I will try to begin talking in a little more, I guess, detail about some of the challenges that I think Commissioner Southmaid has begun to articulate. So we have basically two ways of getting into our courthouse in a way that might put a custody or parenting time in play, and one is, of course, a traditional custody petition. The other mechanism is through a protective order, a civil order process. We've shared with you some numbers here just to give you a kind of a snapshot of bare numbers of what that looks like. So we have statewide numbers on the slide that you're currently viewing. We've skipped 2014 for reasons we won't bore you with, but we gave you numbers from 2013 and then from last year, 2015. We have PFA petitions filed in purple, and in 2013, and pretty consistently in 2015, we got just about 3,000 of those. Now, it's really important to remember here that those numbers include people who do not have children together. So you certainly could have PFA, civil protective orders, from people who have been dating, never had children. You could even have them in between adult children and their parents and the like. So that number does not mean that every one of those 3,000 petitions has minor children of these parties living together. what we learned through all of this, it's probably not surprising to anybody, is that most protective orders and custody petitions, and because we have slightly fewer, about 2,500 or so custody petitions filed a year, most of those never get to anyone in a black robe. Many of them are dismissed either for lack of ability to obtain jurisdiction over the other party. We've identified a hole in terms of one of the other ways that cases filter out of the system is through lack of filing fees. In our custody cases, we have the requirement of the parent education certificate. In many cases, sort of wash out of the system when the petitioning party on a custody case is not able or does not complete that process. So we have many cases that are eliminated through dismissal. You can also see we have a lot of cases that are resolved, not surprisingly, by consent. And that's across both custody and PFAs. And then we've identified here, and you'll see on our little chart that we've taken off, we've told you how many protective order petitions go to a hearing, but we've not told you how many custody petitions go to a hearing, and that's because we've identified data holes around that. We're not, many of the custody cases are mediated successfully. We kind of know about that, but we've not been able as of yet to figure out exactly how all of the custody cases are resolved, keeping in mind that commissioners like Commissioner Southmaid and I are doing the protective work while our judges are doing the custody cases, and we have what I would think of as a kind of two silos standing alone. So commissioners are gathering a great deal of information and evidence in the protective order proceedings about domestic violence in a family. That tends to be isolated from and does not translate over to the silo of the custody silo, which is heard by judges. We also have a bit of a data problem that we've identified. Maybe one of the best learnings out of our work so far is learning that we don't have good data about what happens with all of our custody petitions. We do think, though, we can draw one conclusion, and I think I would suggest a very important conclusion, and that is that the cases filed in our court involving children who might be exposed to domestic violence, whether they come through the traditional custody petition or they come through the protective order process, most of those are never considered in any fact-finding way by either a commissioner or a judge. So the numbers are very small. The numbers of cases that actually receive direct judicial intervention are comparatively small.
I want to say that about 1/3 of our PFAs in some way involve children, and that children, we do gather the data on, as I think we're required to, on children involved or of the union in PFA cases, in our domestic violence protective order cases.
I'm not going to spend a lot of time on the next three slides. Basically, we've broken down our statewide numbers into our 3 counties. The counties are somewhat inconsistent, and we believe that's partly because of coding differences in the way we collect case dispositions and outcomes. We've identified some, you can imagine, kind of local practices that develop with our staff when they're trying to figure out how to code the disposition of a case. We also have identified what we think are more substantive differences between the counties that we've not entirely figured out the cause of. It might be related to how law enforcement and other stakeholders in the system respond to domestic violence. But we actually think this is kind of an exciting opportunity because it gives us a way, I think Commissioner Southmaid touched on this, it kind of gives us a way, almost a laboratory in each of those counties to test different ideas about how to improve the system. So that's what we think, why we think we're a useful part of this demonstration project is because we have just the 3 counties and we can use them in different ways.
Commissioner Berry, I did want to just give some numbers for 2013 with regard to PFA petitions where there were they identified children of the union, and that ran about 1,209 petitions. So it's about a third of the petitions that were filed for PFA seem to have children involved.
Great. Thank you, Elle. Thanks for reminding me. We've talked already quite a bit about our protective order process, and to kind of just orient you further, the orders for protection from abuse come up under one title of our code that is separate from actually where custody petitions are begun. I've already told you all that protection from abuse orders, civil protective order proceedings, are heard by commissioners, which is why you're talking mostly, or why Commissioner Southmaid and I are sitting here with you today. Commissioners have the authority, the statute provides for an ex parte protective order process, so you can walk into our court on a Friday afternoon, fill out a petition for a protective order, and if you support it with the right affidavits, we will have an immediate ex parte hearing without the other side there. If there are obviously if there's a risk of domestic violence, and based on that ex parte proceeding, we will issue a temporary protective order. Typically, it's good for 10 days, and that's because in that time frame, we're going to have you and the other side back for a full evidentiary hearing to determine whether, in fact, there's been domestic violence, and if so, what to do about it. Probably obviously, because most of these statutes came up under the Violence Against Women Act, there's a full panoply of relief that we can offer as part of our protective order process, and most pertinently, that includes awarding temporary custody of the children of the parties to either the petitioner, which is pretty a typical response, but the statute also gives us the authority to temporarily award custody to another family member as well. Not often used, but it's out there. We can also enter temporary, again, visitation provisions as part of our protective order process. Our protective order statute has changed a bit over the last couple of years in terms of how long our temporary orders can stay in place. The protective components of them plainly can be up to a lifetime order of protection. The temporary provisions with custody and visitation are more limited and truly are temporary. And so what that does, in theory at least, is buy parties time in a somewhat safer environment to file a custody petition seeking more permanent custody and visitation relief. We're not always really sure that happens, or that it happens, or that when it happens, it carries through to fruition. So part of our premise and part of the concern we have, maybe one of the questions we have, is whether or not many of the temporary custody and visitation arrangements that commissioners are making in our state on a theoretically temporary basis don't in fact often become the de facto custody arrangement for the children over quite a long period of time. In contrast, and probably not surprisingly, on custody decisions themselves, that law is created in a different title of our court's jurisdiction. It's not surprising we have a best interest standards. We have 9 factors, 9 statutory factors to look at in determining custody, all related, of course, to the broad goal of children's best interest. We specifically have a separate subchapter where there's been evidence of domestic violence in the custody case.
Our best interest factors also include specifically evidence of domestic violence, although that shouldn't be necessary, as domestic violence would be relevant to many of the best interest factors. We have a separate chapter which has a rebuttable presumption against custody being awarded to, or even shared, or even joint custody to a perpetrator of domestic violence. but that is a very special definition. A perpetrator of domestic violence under Delaware law is a person who's been convicted of a felony or certain enumerated or just a few enumerated misdemeanors, including conviction of a domestic violence protective order where there was a threat or actual violence. Defense attorneys are well aware of that distinction and have to have their clients plead guilty to one of the non-enumerated misdemeanors or take a first offender's plea so as to avoid that presumption, and it is very often taken advantage of. Mediation. We have, as I said, we have that diversion services unit staffed by mediators, and under this chapter, mediation is prohibited in cases where there's been any finding by a court of domestic violence or where there is any no contact order currently in place. There's also a section that prevents most sex offenders from participating in mediation. This has been, we have been toying with in this project whether that's a problem, in that this rule is both over and under inclusive, meaning that there are people who are being barred from mediation who could probably handle it and have some and participate in resolution of their own problem, of their own conflicts without any risk. And there are plenty of people who are going to mediation who have domestic violence in their relationships and who are not very well served in a mediation context. And among our projects, hopefully you'll hear about later if we don't run out of time, we're going to suggest some resolutions of that problem.
Okay, so turning to the project itself, we of course have a management team, which includes our chief judge, 4 additional family court judges, 3 family court commissioners, 5 family court administrators, and the project coordinator. We also have a very active community partnership and members from the community organizations, advocacy groups, and other groups who really have provided us with a lot of guidance and good work. We include an associate professor from the University of Delaware who is our research advisor, the lead attorney from Community Legal Aid Society, who is the co-chair to one of the subcommittees that you'll be hearing about, the director of advocacy and policy from the Delaware Coalition Against Domestic Violence, who's also a co-chair on one of the subcommittees you'll be hearing about, and the executive director of the Domestic Violence Coordinating Council. In addition to the management team, we do have the collaborative work group, and everyone on the management team is also on this work group, and so we're just talking about those additional people who are on. The program director from an organization called People's Place, which is a wonderful community service organization, does a lot of work. The clinical director from People's Place, the executive director of an organization called Child Inc., which provides both advocacy and other domestic violence services for victims of domestic violence. They also do some parenting, some of the parenting classes that have been approved by the court, and have engage in other services that help victims and also address some issues for batterers. The cabinet secretary of the Department of Services for Children, Youth, and Families, which is what most people think of as the kids department, but it is the department, the state department that addresses things like child abuse, other services for families, and youth, and then we have the chief of police from the Wilmington Police, an associate professor from Widener University School of Law that has done some work with and addresses advocacy and other services for victims. The director of the family division of our Department of Justice, who looks at the mostly the criminal pieces that have to do with domestic violence, a corporal from the State of Delaware Police Domestic Violence Unit, the executive director of the Criminal Justice Council, of the Delaware Criminal Justice Council, a master police corporal with Newcastle County Police, 2 attorneys who are members of the Delaware State Bar, and our director of the court services. So these people are helping with guidance and addressing the project itself.
Okay. With the support from our TA organizations, we conducted focus groups. I say we, meaning everybody except me, because it was previous to my being brought on board with the project. The court conducted focus groups, or I think it was before it said affinity groups, to initially collect the data for analysis. Those focus groups included judges and commissioners, mediators, staff, DV advocates, and domestic violence survivors. The data that was gotten from those focus groups helped inform us to redefine the court's vision with its goals for the program, narrow the issues to be addressed in our implementation plan, and establish 9 key activities to address the implementation phase of the project. And then was created the differentiation committee and the access to justice subcommittee, and that's when I came on board. And the access to justice subcommittee was originally called the intake committee, and as we identified the issues, we quickly realized it was much broader than that, and that we had to be looking at the total litigant experience as they approach the court. Our vision has been to improve family court's response to custody cases involving domestic violence, and we had 3 goals. We wanted to make sure that orders in PFA proceedings involving custody were safe and appropriate. We want to make sure that court orders in family court for custody were responsive to best interest factors and incorporating domestic violence and parenting capacity in light of domestic violence. And we need to have a multidisciplinary systemic approach to identify domestic violence in all cases.
We, probably not surprisingly, kind of the way Commissioner Southmead and I have already been talking, one of the issues, big concerns we had identified as we were going through implementation plan issues was just absolute confusion between how to use information about domestic violence in the protective order context and in the custody context. So again, we had a lot of information about domestic violence in the protective order context, and yet it seemed like that was not necessarily a good context to make long-term parenting and custody decisions. On the other hand, we weren't entirely clear how domestic violence information was being used in those settings where it would seem to be appropriate to use it in terms of making longer-term custody decisions.
You can imagine how, it's not hard to imagine how awkward or difficult it is to make a custody decision in a domestic violence protective order context. You sit and hear a bunch of evidence about whether or not a particular act of domestic violence occurred, or maybe a series of acts or pattern of acts. And in the end of the hearing, well, let's say you decide that no, there's not enough evidence for me to come to that conclusion. Thanks, everybody go home. No custody order, no protective order, nothing. All right, the other possibility, you find that it did occur. Okay, you have custody. Sir, you don't. Let's see, when should you have contact with the children? I know, we have this nice visitation center down in the next town. You go there for an hour and a half every other week, and somebody file a custody petition. That'll get this going. That's basically how quickly and how deeply it gets considered in many cases.
And then, maybe a year later, if a custody case has been filed, if that custody case has navigated its way past the roadblocks and hurdles inherent in our system, your case will go in front of a judge. And at that point, evidence of domestic violence, if it's not been preserved in any other way, may or may not really ever get addressed in your custody hearing. A lot of that information has been lost. In fact, we have begun calling that phenomenon the phenomenon of disappearing DV. It just seems to go away. So there's a lot of confusion and concern as we are developing our implementation plan around those issues. And then, of course, also, and I think Robin is on the line with me, and she's always been wonderful about reminding me that we also, there's a lot of cases where we just don't think we're identifying domestic violence at all. So cases don't necessarily come in through a PFA process, but they do come in through a custody case. Maybe there's just simply no criminal conviction. There is no red flag from the file standing out hollering domestic violence. Well, where's that information going? Surely some of those families struggle with those issues as well. So we had developed a bunch of different activities. Ellen tells me here it's 9 key activities we developed to try to begin getting at all of those issues. Don't know that it's necessarily to kind of read to you guys all that we've done. I will say one of the activities we've completed is a case file study. That came out of our contract with the National Council and through one of the subcommittees. We completed that and began then developing, we began to use that to try to figure out how many cases, I guess, part of that was to figure out how many cases actually got to a hearing process and were part of a contested evidentiary fact-finding process about domestic violence in custody. Others of our activities, we've begun the process of trying to look at a workload analysis because, again, one of the barriers I think we've begun to identify is you've got one type of judicial officer hearing one case, another type hearing another, and that, when it's part of a long-term system, when you start talking about changing that, you're talking about workload issues that aren't always easy to tackle. I mentioned earlier that one of the other projects we have going on is an analysis through the National Center for State Courts, a weighted caseload study that we're currently engaged in to try to figure out how much time each of us spend on what. So that is another activity that's part of what is going to inform the results of this grant as well. Commissioner Southmead, did you want to talk a little more about the litigant experience in Activity 4 and 5? Because I think that picks up more with your committee.
Yes, our subcommittee, the first thing we did, actually, was arrange to go to each of the courthouses, and we just sat in the lobby on a protection from abuse day and on another day in each courthouse to see what it was like to be a litigant. And, we didn't hide who we were or anything like that, so it wasn't absolutely authentic, but it was nevertheless enlightening. Then we would have discussions about our experiences, and let's just say we were appalled at what it was like to be a litigant in these activities. So often we plan or we design these calendars and how we do things just to get the widget through the system. Just what makes us feel like we are being most productive, but not with a view of the traumatic and re-traumatic experience we are putting our customers through. We also reviewed all the written materials related to PFA and custody processes, all the statutes and forms, and we started developing projects of what we wanted to accomplish. And I'm actually going way through this because we only have 15 minutes left, and these 3 things are what's most important to me, and so I want to get to it. we formed 3 committees. Where are they? Here. All right, we formed 3 work groups. First work group is to modify our mediation process. Yes?
I'm moving you to get to the Access to Justice Committee, and we'll go back to the Differentiation Committee once we go through these slides for you, Commissioner.
Okay. What page are you on? Okay. All right, we have these 3 work groups. One is to deal with mediation, and our basic idea is to create a system by which we can take the cases that are headed to mediation, divide them into 3 categories. One would be the ones who have no domestic violence history. I'll get back to the fact that cases with no domestic violence might actually have domestic violence in them, but ones with no domestic violence history, and those who are not those perpetrators of domestic violence, those who are, as I said before, not allowed to go to or not allowed to have custody, presumptively not allowed to have joint custody or primary placement of children. And we want to put them through an assessment, something like the MASIC 3, which some of you might have already be familiar with, to determine whether these people are eligible for mediation or appropriate, I should say, for a mediation program, or whether they can do a mediation that is different from 2 people or 3 people sitting in a room, but maybe do shuttle mediation or caucusing, as we call it, not conferencing with everybody's in the same room, but caucusing when you shuttle between the 2 rooms. Maybe they're appropriate for that. Maybe they're not. We would see through the assessment, give people maximum opportunity to participate in the resolution of their own conflicts. People for which there was no no record of domestic violence, we would give all litigants the opportunity to opt in to the assessment program so that they would not necessarily have to go through our traditional mediation. And we would create it as basically an absolute right that nobody would ever be compelled to participate in a face-to-face mediation conference. They might be required to participate in a meeting with a mediator to see whether or not there's any chance for a settlement, but never face-to-face. We think that this would give more people the opportunity to get a custody order that was responsive to their needs. Our second group is to reform our resource center to make it safe, welcoming, and helpful. Right now it's not, at least not in all respects. And we have to get over the idea that of not giving legal advice and embrace a way that we can help people without breaking any rules. Our third committee is to reform our PFA, or Domestic Violence Protective Order, calendar, and that is the calendar in which everybody has to show up on the same day and get everything done at the same time. Everybody goes through like cattle. As a matter of fact, the name of the work group is the end of the cattle call. Why do you have to do everything on one day? Why can't we divide it through several days and treat people a little more civilly? And I wanted to get that all in before the end of the program.
And maybe, Ellen, if we can maybe flip back to slide 25, I think that'll kind of pick up Commissioner Southmaid's last comments about the PFA Day. Our other subcommittee, the Differentiation Subcommittee, one of our first activities was the case file study with the National Council. And some of the results and outcomes of that study are on slide 25. Obviously, PFA outcomes are on the left, and that custody outcomes are on the right. The thing that jumps out immediately about both of these numbers is in most cases involving kids where there's custody, where there's domestic violence potential, some of them get dismissed and just aren't heard. Many, perhaps not most, but a significant minority of them do. Many of them, another significant minority percentage, go to a consent order. Maybe that's a good thing, maybe that's a bad thing, but it's generally done without any kind of judicial oversight other than a kind of a bare reading and signing off on the orders. Many of our PFA outcomes, we enter, of the cases that go to a full hearing, most of them are granted, most of those result in a protective order, the ones that actually go to a hearing, about 16% of them. Of the cases that go to a protective order hearing, only about 7% are denied. Of the orders that are granted through the PFA process, whether by consent or whether by after a hearing, about 67% of those include some custody provisions. In contrast, the custody outcomes, again, many of the custody cases get dismissed. Many are resolved by consent, even though we know, or think we know anyway, that there may be domestic violence overlays with some of them anyway. Cases that actually are resolved by some level of hearing often result in joint custody awards, 65%. Many of the ones that are resolved with some judicial intervention result in primary residence with the mother most of the time. And then we also, of course, have learned that very few people have representation, very few petitioners, and I will also say very few respondents, either party, have representation in most of these cases. The point here, I think, is to drive home that there's just not a lot of cases being heard in a fact-finding way by either judges or by judges in custody cases. As we move on, what we've been struggling with in my subcommittee, the differentiation subcommittee, since all of that learning, since our initial case study, was moving on to an impact study, and we're actually hip deep in trying to figure out what we want that impact study to look like. It certainly is going to involve a subset of files that include both custody petitions, families where both a custody petition and a PFA petition has been filed, and an intensive review of a subset of those files to try to begin getting at factors that might be influencing, what factors might be influencing the outcomes in those cases. We are planning an activity for the end of March to begin that process. We've actually identified factors that we want to look at, and then we're actually scheduling that activity for the end of March. So that's the next activity in terms of trying to actually get at what happens when Commissioner Southmade's subcommittee has done all of its wonderful work, and we actually have a receptive, safe place for people to come and have their custody cases resolved. Then what happens? How do we get them in front of someone in a black robe, and what does that person do with information about domestic violence? One of the other learnings, and another significant learning we probably should have put ahead a slide, but on our slide 27, we talked a little bit about how, when I said it takes, a year later your custody case gets in front of a judge. Slide 27 tells us 271 days from the time a protective order decision is made to a custody decision, even a little bit longer if the PFA was active. And then perhaps the most concerning figure of all is that only 35% of the custody orders that were entered include or address allegations of domestic violence or mention the fact that there had already been a protective order issued. Now, I will say that it's very important to keep the context of that number in mind, because we are talking about a very, very small number of custody cases. But it was of concern that when we began looking at those custody decisions, even though there was domestic violence information in the very files, the custody decisions were not necessarily grappling with that.
Okay. we still have a few steps going on with the other groups, and one is that the management team is beginning to meet more often, but it's also planning to look at recommendations from both of the committees in late June. And those committees, the recommendations of the committees will hopefully address some of the issues that Commissioner Very and Commissioner Southmaid have told you about today. It's pretty clear that there's some directions that both committees want, and they should be providing that information to the management team in June. The next group, let me get to those slides, I'm sorry. Okay. Then the collaborative team. There are two steps that we're addressing with the collaborative team, and those next steps include really to create some multidisciplinary training with all of our community partners around not just the implementation and the execution of orders, but also the kinds of things that we should be saying in common to people who have either come to the court or gone to the police or gone to an organization and are trying to either file for custody or for a PFA. And also all the members of the collaborative team to actually participate in that multidisciplinary training. So we are here, we have a few more minutes, and would be glad to take questions. Are you still there?
Yes, I'm still here. If anyone has any questions, you can feel free to put them in the chat box, or you can send me an email if you think of anything later. I'm typing my email into the chat box right now. Once the webinar is over, you will be directed to a survey, and you're more than welcome to leave any comments there as well.
Okay, is that it then?
That's all. Thank you all for coming.
Okay, thank you all. Have a good afternoon.
Thank you.